Good morning, good afternoon. Thank you guys so much for joining us. We are so excited to have you here. We'll get started in a few minutes. As we do, we'd love to hear where you're joining us from. So if you want to, you can open up that chat box and go ahead and put in there your city and state that you are joining us from. And I'll open up that to see where you guys are saying. Jacksonville, Winter Springs, Apopka, Claremont, it's coming in. Orlando, Vieira, Winter Garden, awesome. We're so glad you guys are here. If you just are jumping on, thanks for being a part today. We're excited to get into some very useful information. So if you want to open up that chat box and let us know where you are joining us from, that would be great. And we will get started here in just a couple minutes. Cayman Islands, but U.S. citizen. Wow. Washington State. Very cool. Tampa. This is great. We are so glad to have you guys join us today. As you're joining us, another question, love to hear. Your VIP or your child or adult that you are a parent or caregiver to, we'd love to hear their age as well. If you can put that in the chat. Great, awesome. All right, just a couple more minutes and we'll get started. So go ahead and get that cup of coffee refill or water or whatever, and we'll be getting started here soon. All right. All right. Thank you so much for joining us today for our Guardianship, Special Needs Trust and Estate Planning What Now webinar. We are so glad to have you join us. We are going to get started just with a little introduction of Nathaniel's Hope. This may be new to some of you all, so I have a little video I want to share, and then we're going to jump in today's webinar with some good information. Let me get this pulled up here to share with you guys.
Hi, we're Tim and Marie Cook, Nathaniel's mom and dad, and we're here to tell you about our journey with Nathaniel.
Our journey began with our son on June 6, 1997, and our son's name was Nathaniel Timothy Cook, which actually means treasured gift from God. He was our third child. We had two daughters, a 3-year-old who is Ashley, and a 5-year-old who is Brianna. And immediately we were thrust into caring for our little boy at Arnold Palmer Hospital.
He spent the first 89 days of his life just fighting for his life, and I remember it was such a hard, trying time to try and raise our two daughters while having a son that we were fighting for his life every day.
And after 89 days, we took him home, not to a normal nursery, but actually to a small hospital room that had a heart monitor and a sat monitor, and he was on oxygen, he was on IV, he had a feeding tube. And Marie found herself at a place of caring for him 24 hours a day, 7 days a week.
We actually consider ourselves RPs, registered parents, because we had to really equip ourselves to care for a child that had multiple medical needs.
And actually caring for our son, it actually consumed our lives. It was our whole life evolved around caring for our son. I told the people I worked with at Regal Boats here in Orlando that I had these 5 F's. I have faith, family, friends, finances, and flexibility, these 5 F's, and we were barely making it. And I said at the time, I don't know how people that only have 2 F's or 3 F's, how can they possibly make it when we're barely making it with these 5 F's?
Oftentimes families are in survival mode, just taking everything it takes in you just to care for your child, just to get through the day. And so we became part of that community, and it was really tough.
He had numerous surgeries in his life, actually more than 7 of them, but 3 of them were for craniosynostosis, and that two of them we had here in Orlando, and then we took them to Dallas, Texas for a third. And the surgery went well, but he ended up getting pneumonia. And during the course of that time in the hospital, there's a nurse that's standing over our son's bed, and she's weeping. And she says, there's just something about this boy. There's just something about this boy. And as we begin to talk, we find that she's of like faith. And she says, I don't normally do this, but can I pray for you? And we said, of course. We're spiritually bankrupt, physically bankrupt, emotionally bankrupt, after just fighting for our son's life again 11 days in Dallas. And as she prays, she didn't pray a typical prayer. She prayed that my son's purpose would be fulfilled. We thought kind of an odd prayer because he never walked or talked or ate with his mouth, but she prayed that his purpose would be fulfilled.
A year later, unexpectedly, without our permission, he had a change of address from earth to heaven when he passed away in my arms. And we realized at that point that that wasn't the end, but it was the beginning, that God wanted us to steward our whole journey with Nathaniel. Because from the time that we found out we had a child with special needs to the time that God took him home, it was a journey, an unanticipated journey, a path that we never expected.
There's a paraphrase quote by author, philosopher named Soren Kierkegaard that says, we live life forward, but we understand life backwards. We live life forward, but we understand life backwards. And so we were living life forward for 4.5 years. And now, after his death, we realized that we needed to take that which we learned and apply it to life. And we realized that we needed to do that by starting a ministry to cheer on families that only have 2 F's or 3 F's. And on June 6, 2002, on Nathaniel's birthday, we dedicated a ministry called Nathaniel's Hope.
So Nathaniel's Hope is...
Right. Well, that is our story. I'm Marie Cook, and my husband and I are co-founders of Nathaniel's Hope. And we know that that's our story, but we all know that everybody that's watching here today, you have your story. And our heart is to join your story and to cheer you on your journey and to celebrate your VIP, who we like to call kids. VIPs, kids with value and incredible purpose, no matter what age, if you're young, if they're older, they're very valuable and they have purpose in God's eyes and in our eyes. And so we're here cheering you on today. So we are privileged that you're joining us today. You know, though our son was only with us for 4.5 years, I remember my husband and I having discussions, even at his early age, of what are we going to do? Like, we knew that he would need extensive care through the course of his life. You know, of course, we were thinking he'd be with us a lot longer, but we were concerned even at that age, you know, what are we going to do? Who's going to take care of him? And we can't take care of him anymore. So we're happy to be here today to have those conversations with you. And, you know, our goal is to walk this journey with you. And we're excited to have 2 people with us today that are going to help us answer some of those questions, you know, so for some of you you're right in this time season that you're thinking about it. Others, it might be down the road, but things that we need to consider. And we don't want to overwhelm you today, but we want to be helpful to you today. And I'm so excited that today that Lynn Aust is with us. She is a longtime friend of Nathaniel's Hope, a longtime friend of the and I prayed for our little boy even when he was here. So that's a long time. And she graduated cum laude from Stetson University in 2001, has a doctorate, Juris Doctorate, and shortly afterwards established Aust law firm. And she's got a lot of credentials. She's a member of the Orange County Bar Association, the Florida Bar Real Property, Probate and Trust Law Section, volunteer mediator for the 9th Judicial Circuit Court. I can go on and on about this lady. She's done a lot, but the most important thing you need to know today is that she loves VIPs, she loves families, and has a heart to want to help you and serve you. So Lynn, we're so happy that you're with us today. Thank you. And then along with us, we've got a Caitlin Massey who's with us, and she's got her Juris Doctorate from Barry University, from Dwayne O. Andreas School of Law in Orlando, Florida, and graduated from the University of Tampa before that with a bachelor's in business and marketing. And she's been a part of the Lynn's team, doing a whole lot of different things for years, and so comes with also a very big heart. And I'm just excited to have both these ladies with us today, just to share they just have offered to do this, to want to be helpful to you, the VIP community, the caregivers, to say, listen, these are things you have to think about, and we want to help you kind of think through these things and navigate through them. So thank you so much, ladies, for being with us today. And with that, I'm going to turn it over to you, Lynn.
Okay, Caitlin's gonna start first because she's got the more difficult part. And I'm really glad so I can kind of tamp down my emotions after that video. So, Caitlin, take it away.
All right. Well, thank you, Carrie and Marie, for having both Lynn and I here to speak on this very important topic of family planning for loved ones with special needs. I'm going to start off the presentation to a discussion with you on the options available to families to assist with making decisions on behalf of their loved ones with special needs. So, Carrie, if I could go to the next slide, please. All right. So many of us have heard of guardianship. Guardianship is the court process to gain authority to make decisions on behalf of an individual or loved one with special needs. Guardianship is not always necessary, and I'll go into that next. In the state of Florida, guardianship is a two-step court process. The first step is to determine if an individual has capacity, and the second step is to determine who should take to assist or appoint to make decisions for that individual. The next slide, please, Carrie. So incapacity, that first step where the court makes a determination of whether an individual has capacity. In the state of Florida, the court will appoint a 3-member examining committee to determine whether an individual has capacity. The committee typically consists of a doctor, a nurse or professional guardian, and a lay person. Each committee member will report back to the court with their findings. The committee is looking to determine whether an individual person can make financial decisions on their own and personal care decisions. It's important to remember that capacity is determined in the state of Florida at the age of 18. And incapacity can be brought on by an accident, an illness, an age, or in many of the cases of our families with special needs, an infirmity that came on at birth. If we go to the next slide, Carrie. So can guardianship be avoided? Absolutely, in certain cases. Traditionally, the option of setting up incapacity documents for an individual with special needs is for high functioning special needs individuals. So if your loved one with special needs is the age of 18 or older, is mentally able to understand in a general way their legal documents and physically able to sign legal documents, then we may be able to, or any attorney that you are working with may be able to set up what we call incapacity documents or advance directives. If we could go to the next slide, I'll go over what those documents look like. So incapacity documents consist of a healthcare surrogate designation. This document is a document which you name an individual and a backup individual to assist you with making healthcare decisions if you're incapacitated. We also would suggest setting up a durable power of attorney. This document names an agent and a backup agent to help with financial decisions when you lose the ability of making financial decisions on your own. And the last document that we include in our incapacity documents is a living will. This document it identifies your end of life decisions and names an individual to enforce those decisions when the end of life comes. In Florida, by having these documents executed, you can handle most, if not all, decision-making authority for your loved one, so that if they're unable to do it themselves. And so I'll go to the next slide, Carrie, please. Thank you. So another less restrictive, less expensive, and less intrusive alternative to full-blown guardianship is called guardian advocacy. So what is guardian advocacy? This is the court appointment of a person to help a developmentally disabled adult. It gives the appointed person the ability to continue making decisions after the child becomes an adult, because once they turn 18, that decision-making authority is no longer the parents to make. Now, how do I know if my child or loved one can have guardian advocacy set up? If your loved one lacks decision-making ability for daily living, or if your loved one was diagnosed with a developmental disability prior to the age of 18, we've listed the intellectual disabilities that are included on our slide here. And if your loved one has a significant handicap as a result of that disability, then you may qualify for guardian advocacy. The next slide, please. Thank you. All right, so what is guardian advocacy? What does this process look like? To apply for guardian advocacy, you will need to complete paperwork and submit it with a fee to your county clerk. The court will complete a background check on the person applying to be the guardian advocate. If there is property or assets involved, the court will complete a credit check, history check on your background as well. The court will then appoint an attorney for the developmentally disabled individual so that their interests are included in the process. There typically is a hearing. This hearing is not a scary hearing. It's typically sitting down at a table with a judge and going over the paperwork that you've submitted. And if you qualify to be a guardian advocate, the court will appoint you as such. If you're appointed, you would follow up the hearing with an 8-hour training course to learn what your duties are as guardian advocate. The important aspect of guardian advocacy that I want to stress is you do not need an attorney, that you can obtain all of the court paperwork from the court or the clerk. They will assist you as well, and you can handle it all yourself. So we're saving on legal fees, and it's something that you can take care of and make sure that you can make decisions for your loved one once they're over the age of 18. And then we can go to the next slide. So I am going to actually toss the presentation to Lynn. She's going to discuss what you can do in terms of your own estate plan to protect your loved one with special needs.
Thanks, Caitlin. I appreciate it. I'm going to add 2 things that I just found out this week, and I haven't had a chance to discuss it with Caitlin. We are lobbying really, really hard with our legislators to change that 8-hour training class to a 4-hour training class for guardian advocate. Y'all have a lot on you already, and if we're successful, yay. And if we're not, 8 hours. Also, the court, you're in Orange County, the court has a self-help center that can help you fill out those forms. And it's typically manned by 1 or 2 attorneys. So that's a good thing for you. You do not need an attorney for guardian advocate. You can hire one, but you don't need one. Okay, moving on to estate planning. You'll probably in this community, you have heard other parents who have children with special needs or adult with special needs. So, oh, you need a special needs trust, you need a special needs trust. Well, there are many different kinds of special needs trusts, so it gets really confusing. So the priority, if your child with special needs or adult with special needs doesn't have any assets, meaning I'm not talking about SSDI, I'm not talking about supplemental income, I'm talking about they don't have a car, they don't have a bank account, they don't have any assets. We don't need to set up anything particular for them regarding property. But when you pass, you probably want to leave an inheritance for that child. And if that child is on Medicaid, which is the government benefit that we all want, especially covering the medications, we don't want them bumped off of Medicaid. We want to protect their Medicaid assets. So you as the parent or caregiver of a person with special needs need to set up your estate plan. Traditionally, it would be a revocable trust. Trust is like a basket. You're gonna eke out a part of the basket for your kids that don't have special needs and define how they inherit. For the child with special needs, it's going to dump into supplemental needs trust. It supplements their government benefits, doesn't replace it. So in your estate planning, you can actually hold in the trust for their benefit a house. They don't take ownership, but they have a place to live. There could be some funds there to pay for caregivers. There could be some funds there to pay for the things that government benefits don't, and they still maintain their government benefits. Now, next slide, please, Carrie. The big fork in the road in estate planning is Plan A and Plan B. Plan A is the simplified, where it's the last will and testament. Many people say, oh, if I've got a will, that's not probate. Last will and testament is the roadmap to the probate court who gets your assets. So if you leave in your will an inheritance to a child who has special needs and they're on or will be on government benefits, that could cause them to become ineligible. The Plan A also includes a power of attorney, healthcare surrogate, living will, just like Caitlin was discussing. Again, this is for you, the parent. All those are good things, but if you have a child with special needs or an adult child with special needs, you probably ought to seek Plan B and embed in the revocable living trust these supplemental needs planning. Now you'll hear revocable trust, you'll hear living trust, you'll hear revocable living trust. It's all the same. So don't get mucked down on that. Just as by way of information, if you're charitable minded and want to be an organ donor, you can do it on your estate plan, but it's better to do it on your driver's license. Again, I'm quoting Florida law for our folks that have joined us in other states. Take this information to your state attorney and verify what your state does. Next slide, please, Carrie. Now, let's say you didn't plan and set up your own revocable trust with the supplemental needs planning within it. And then grandma passes away and leaves an inheritance for your child who has special needs. Or God forbid, your child gets involved in a personal injury, or their parent dies and they get involved in some sort of settlement for a wrongful death. All those things would go into your child's hand. And if they're on government benefits, such as Medicaid, they get bumped off. They become ineligible. So the only alternative at that point is doing the full-blown standalone special needs trust. We'd like to avoid this if we can, because it's irrevocable, and probably the most important and biggest bad part of special needs trust is there is a Medicaid payback provision. If you've done it in your estate plan and your loved one dies, if there's money and assets still in there for them, it goes to whoever your other beneficiaries are. If you have to set up a standalone special needs trust and there's still assets in it when they die, it goes back to Medicaid. So this is a requirement we cannot get around. So you can see the benefit there. To protect inheritances, do it in your estate plan. Next slide, please. The other alternative, if your special needs person is going to inherit, or it's a settlement of some kind, is a pooled trust. You'll hear about this. This is my least favorite alternative, simply because it's irrevocable. Every time you want assets out of that trust, and hopefully we don't have any professional pooled trust guardians or trustees on this, because it's not my favorite. If you need assets to pay for something for the person with special needs, your loved one, you have to request it. Sometimes they say yes, sometimes they say no. There's always a delay. Whereas if you had your own special needs trust, your supplemental trust embedded into your revocable trust, you have complete control. With the pooled trust, it also has that Medicaid payback provision, or if you opt out of that, then you could leave the funds in there for other people in the pool. The definition of pool is the trustee takes assets from several different folks with special needs and pools them together. That doesn't give your loved one more assets, because when their contribution to that pool is used up, then there are no more distributions. So next slide, please. Back to the method I prefer is the supplemental needs trust that is embedded in your revocable trust. Your parents, meaning the grandparents of the person with special needs, can set it up in their estate plan. Just about anybody can do this and eke out in the trust a supplemental needs trust within the trust itself, which is revocable. There's no Medicaid payback. And I realize we're throwing a whole lot of information at you. In 35 minutes, we're hitting probably an 8-hour seminar worth of information. So, and Marie prayed for us before we started, which I loved. Her prayer is to not overwhelm, but to educate. And that's our intent here, is to educate. So I don't expect everybody here to get all of it this first time. This is broad scope information. So you can go to your attorney and get further information customized to your situation. So hopefully at this point, it's pretty clear, I hope, that I'm encouraging you to do your revocable trust with supplemental needs planning embedded in it, so you can avoid the standalone special needs trust. You can avoid the standalone pooled trust. So on this slide, page 12, this kind of gives you broad scope of what that supplemental needs trust. Take this to your estate plan attorney. So, and also make sure your attorneys had some experience in special need and supplemental needs planning, because it's pretty specialized. Carrie, if you'll go to the next, please. Why do I need an attorney? You know, with guardian advocate, the baby guardianship for folks with developmental disabilities, you don't need an attorney. If you're going to do supplemental needs trust or special needs trust, you need an attorney. It's a very complicated, specialized area of law. So when you're interviewing attorneys, it's great, they're estate plan attorneys. Excuse me, but you want to ask the question, how much experience have you had with special needs trust or supplemental needs trust? I know lots of attorneys who won't touch this, so I don't think it would be a rude question to ask. I think that's it for that one. Let's go to slide 14. I'm doing a time check. Okay, we're doing great. I have a whole lot of information for you on ABLE accounts, and we did not put it in the slides other than just 2 pages. So I'm going to go as far until Carrie cuts me off on this, because ABLE account is probably something every single one of you should do for your person with special needs trust, your loved one. An ABLE account is achieving a better life experience. This was passed by our legislators in 2014. And for those of you not in the state of Florida, this was passed federally. So there are ABLE accounts in every state. It's a glorified savings account. For those of you who deal with government benefits, especially Medicaid, your loved one cannot have more than $2,000 of assets, nor can they have greater than $2,523 for monthly income to stay eligible. Well, guess what? This ABLE savings account, you just dump money into it for their benefit, and it's not counted against them. If you have a high functioning individual, they can open it themselves. If they're not high functioning, you can open it with them or for them. So can the grandparent, and dump money into it. Now there's some rules and restrictions. Anyone can add, and this is housed under 529 plans. For those of you who have done college planning for your children and set up 529 plans, which are educational investments for your college-bound kids, this is a 529A, which is a savings and investment plan for your kids with special needs. There are 2 websites that I found in my research. It's ableunited.com, and this is in your PowerPoint, and ablenow.com. Each of them have different advantages and what I see as disadvantages. I'm not going to make a recommendation which. Do your homework, do your research, see what fits best for your family. So if your special needs loved one is receiving Medicaid or a government benefit that's based on asset level, ABLE doesn't count. If you go to the next slide, please, Carrie. What you can use ABLE account, just darn near anything, as long as it improves their quality of life. One of the websites showed this little graphic of health, education, housing. I'm not going to read it all. If you want to go on a family vacation and your person with special needs needs a caregiver, meaning you, mom or dad, or a caregiver, guess what? You can pull money out of the ABLE account to pay for that. It doesn't count against them. Now I'm going off track. The rest of this is not on the slides. I'm doing time check again. We're still good. Okay. I'm going back to my further information on ABLE accounts. So you're just going to have to jot this down. And if you don't get it, email me, because at the end of this presentation, you've got Caitlin's email and you'll have mine. And we're happy to answer questions for Nathaniel Hope lovers, because we are Nathaniel Hope lovers. Qualifying. Your person with special needs, if their disability was onset by age 26. Well, most of you probably have folks that the disability was from birth, a developmental disability. So this should not be a problem for you. They need to either be a US citizen or a legal resident. They don't have to be a domicile or live in Florida. They can live in Colorado. If this is a grandchild for you, that's fine too. A qualifying disability, and the under guardian advocate that Caitlin was talking about, it lists those specific disabilities. They're kind of limited what is covered. For ABLE account, as long as you can document a disability that started before age 26, you're in, or your special needs person is in. I'm not going to go into that. During the application process, it's fairly simple. Several years ago, actually in 2014 when this came out, and I thought, this is a great idea. I need to contact several of my clients who have guardian advocate set up to say, do this, do this, do this. And I'm getting all these questions. How do you do it? I don't know how. So I asked one of the clients that I really liked, and I said, would you come to my office and we sit down and we do the application together? I won't charge you for it. I want to learn how to do it. He said yes. It took us a grand total of 15 minutes. Every question he was asked, he could answer out of his head. There was some documentation that has to be provided after the fact, but documentation you all have, such as a doctor's diagnosis of the disability, photo IDs of you and the person with special needs, that kind of a thing. A birth certificate will work. We already covered expenses in the PowerPoint. Fees for these accounts. Able United charges, no, they don't charge anything to open it. They want a minimum contribution of $25. And Able United right now, if you open up the month of November, will credit the account with a $50 credit. So this is kind of free just to open it. You got to put something in it, got to put 25 in to open it, but you get an additional 50 credited. If you set up your account to electronically deliver, they don't charge you for the statement fee. If your folks with special needs they're high functioning, then you can set up them an Able Visa prepaid card, prepaid so they don't go crazy with it, which is good. And it's only $2.50 a month. So this is our way. We want them to be as independent as possible. So this is a really good way to help with that independence. In addition to that, if your person with special needs is able to work, they can contribute part of their paycheck to Able with every pay period. We'll get into more of that later. With Able now, there is no minimum contribution. Time check. We still okay, Carrie? Okay. With Able now, there's no minimum contribution. Both of these, when you save enough, you can tip it over into investing some of it and saving some of it, or keep it all invested like a savings account. It's completely up to you. If you tip it over into investment, there is an admin fee, and it's pretty reasonable. It's 0.29%, depending on the investments that you select. And you can go hair on fire risk or no risk at all. It's completely up to you. So I already told you I set up this online with a parent years ago. It was very, very easy. What happens is after you set it up, 3 to 5 days later, you get a confirmation email. And once that's done, you get that confirmation email, then you can start contributing, and you get on the phone to all the family members saying, here's how you do it. Dump some money in there. You can contribute with check, money order, credit card, automatic contributions, payroll deductions. This is just as easy as it can be. You can even transfer money online from your bank account to the Able account. You can direct Social Security, supplemental income, SSDI into this. Now here's the kicker you have to maintain. The maximum annually you can dump into these accounts is $16,000. This is tied with the IRS gift exemption amount. We can gift up to $16,000 a year without gift tax consequences. So if gift taxes goes up, probably the maximum that we can dump into an Able account, that's a legal term, that we can dump into an Able account will go up as well. Now, if your person with special needs is working, in addition to that $16,000 annually, they can dump a maximum of additional $12,880 from their paycheck into that account. So I'm not doing the math. So 16 and 12, 880 if they're working. With Able Now, once the balance turns to $2,000, you can start investing. The lifetime maximum on this is $418,000. And if you think about it, that's an easy way to provide for your child with special needs without dinging them on government benefits. With this protected, it is FDIC protected up to 250,000. So this is a great way to take care of them outside of your estate plan. So if you don't want to come to an attorney to set that up, at least do the Able account. Okay, taxes. You and other people who are donating to this, it is not tax deductible. So keep that in mind when you're calling grandma and grandpa saying, you're not going to get a tax write-off. This is because you love my child, put it in. Let's see. The distributions from the Able account are not tax deductible to you or your child as long as they're used for some of those qualified expenses. Again, the definition, does it improve their life? There's some tax forms that you have to fill out to prove that you used it when you file your personal 1040, but it's simple. If you need to know, it's form 1099 QA distributions, and it's form 5498 QA. So it's 1099 QA distributions and form 5498 QA. Okay, I already discussed withdrawals are easy for this. You can use that Visa prepaid. You can that's under Able United. You can transfer money to a personal bank account. It could not be easier. It could be online bill pay. With Able Now, you can use a debit card. You can transfer funds to online or online bill pay. Here, one more little hook on this. Medicaid. If your person with special needs receives Medicaid or received Medicaid during their life, and not all the funds were used up by the time they pass, we are finding that Florida Medicaid is not filing a claim for the funds. There is no requirement of Medicaid payback. However, if you as a family want to access what's left in those funds, that's probate. And in the probate, we have seen a couple of Medicaid creditor claims filed against it. So use it, just use the money. That's my best advice. Both of these Able online accounts have newsletters. This program has changed dramatically since 2014 at its inception. So it pays to stay up with the changes are. Get on the newsletter. If you're going to do an Able account, get on the newsletter and see what the changes are. That is all I have on Able. Kayla, do you have anything that I missed that you need to fill in?
I don't think so. I think that was, I'm glad we got that extra information.
I do too. I didn't think we'd get to it, so this is good. Okay, I think we need, hey, I made it. Do we need to do Q&A?
Yeah.
We have lots of questions. First, I want to thank you both. Wow, what a source of information. I was taking notes over here just because I'm learning a lot about this and want to get better educated about it. But wow, and like we said earlier, we don't want you parents or caregivers to get overwhelmed by this, but just take it step by step, you know. And we'll put up contact information afterwards, both for Lynn and Caitlin, if you have questions. But also wanted the question has come up here a lot in the chat that we will have this recording available for you so that you'll be able to watch it again and again and again and again to pick out different pieces down the road. And also, I know there was some question about closed captioning. We're looking into how we can close caption this as well in a recording for the future. So, but Carrie, I know there's so many questions. I don't know how you pick those, but
Yes.
you're for it.
There have been a lot coming in. So we're just going to take a little bit of time to answer some of those. And we'll put up the contact here for Lynn and Caitlin in a few minutes that, you know, if something didn't get answered here, they can be reached out to and help direct you what's best in that. I will ask, I know so many of you have put questions in and there's been lots of conversations since. So if your question did not get answered. If you can put that in the Q&A there, and then that will help me know what we still need to answer. But I did take a couple pictures to help me remember as I saw stuff coming through. So Martha was asking, we established our child special needs trust in Kansas. Do we need to have it updated according to Florida requirements?
My recommendation would be let a Florida attorney review it, because even though Medicaid is a federal funded program, it's administered by Florida law. So we want to make sure what's in the special needs trust doesn't conflict with Florida Medicaid. If it's a standalone, question doesn't say, if it's a standalone special needs trust, or if it's just called that and it's actually a supplemental needs trust, just let a Florida attorney review it, who's got special needs trust background. You know, just if it's irrevocable, which it probably is, if it's standalone, there may not be a whole lot we can do to alter it. You got to read the document to find out, though.
Okay. Kristen is asking, how do we get SSI set up for our son? Who can we contact for help? We tried in the past and did it incorrectly, and Medicaid.
Okay, we don't do that, but if you'll email me, don't y'all call me. I won't pick up the phone. Email me. And same thing for Caitlin. She don't pick up the phone either. If you email one of us, we'll send you Sarah Jacobs' name and phone number. She's our go-to for all things Social Security, particularly if it was denied. She's really good, and she's got a heart for people.
And we'll put up that contact information here in a minute or two. Martha was asking, can we contribute the whole amount our child gets from SSI to her ABLE account? Is there a penalty?
As long as it doesn't exceed $16,000 annually, yes, you can do it.
Let's see. What is, Brooke is asking, what is an irrevocable third-party special needs trust?
Okay, that is often called D4A. It's irrevocable, meaning once you set it, it's set in stone. You can't make changes unless a court approves changes. The benefit of that is if your child with special needs already owns the asset. If it's a future asset, meaning the person who's going to give them an inheritance hasn't died yet, or even if it's a lawsuit that's occurring, that they would be the one to receive, that's when they need this irrevocable special needs trust, which has that ugly Medicaid payback provision. But in those scenarios, we just try to spend it, so there's nothing left when they pass.
All right.
I hope that gave her what she's looking for. I'm not exactly sure.
Okay. Let's see. Dave is asking if receiving survivor benefits is SSI, is that in jeopardy? Is Social Security in jeopardy?
If what? If
Receiving survivor benefits?
If they set up an ABLE, is that what they're asking?
Dave, if you can give us a little more information, or if you want to contact them when we put up their information. Angel is asking, can both parents have guardianship?
Oh yeah, we call it co-guardian advocate. So when you get the forms from the court, again, everybody, this is Florida law, you get forms for the court, everywhere it says petition by guardian advocate, write co above it. And everywhere there's a signature line for one, you draw another line and the other one signs. You alter, and the court will take, not from us, but from non-attorneys, handwritten stuff on the petition. And you do an application for each of the parents, because they're going to do that background check. You're going to do an oath for each of the parents. The court has a list of all the documents you need, and then you just get them. Fill them out.
Perfect. And then Kendra asked, can we retain Aust law firm for help with guardianship? Yes.
We'll get that. I will put up that information. Maybe
Yes,
we
we
have one
will.
time for one more question here, which I think there might be parents on here, caregivers on here that's saying, "Oh my gosh, my child is 18 years old. I have done nothing." Can you just kind of give them hope? Like, what is the first step to start with like that?
It's too late. It's not too, Caitlin, do you want to answer this or can I step in?
You can go ahead, or I can, whichever way.
Caitlin knows it all. I talk more. Caitlin's real quiet. We're a perfect match. It's not too late. If your child, in fact, when we were putting up ages, I saw lots of 17-year-olds. 17 is when you need to start thinking about guardian advocate if it's a developmental disability, because you can't file anything to set up guardian advocate until they're 18 or older. So if your child is 20, 26, 36, whatever, and as long as you have a written diagnosis that it manifested earlier, developmental disability means from birth or shortly thereafter, from the court's perspective, then you can go forward with setting up guardian advocate, which is highly recommend. You don't need an attorney. Now, regarding the estate planning, anytime you do it is the right time. Your attorney can walk you through all the ins and outs. Caitlin covered the incapacity or advanced directive documents beautifully. Plan A is the simplest plan, but that will not provide an inheritance for your child who has special needs. Now, I hear this a lot. Many times my families will say, well, their older brother will take care of them, so I'm going to leave everything to the older brother. Well, that's great. He's not bound legally to do so. He's bound ethically and morally. So you know your family best. It's not too late. Just get started on it now. If they're 18, 19, 20, it's time to get started.
Okay, well, thank you. I know we're going to have lots of questions. I'm sure your email boxes are going to blow up. So thank you for being willing to answer. But Carrie, can you throw up the slide that gives information if you want to contact Lynn or Caitlin? There's their emails. Again, don't call them because they won't answer the phone. They're busy doing helping other families and everything. But thank you for your generosity to answer questions. And as well, prior to this webinar, we were just saying, like, well, we're going to need another webinar with you. And so we're going to send you all a survey that maybe we'll ask some questions and we can maybe target it on more specifically, because you could actually swing off many webinars off of information that was given. We'll see what's most helpful. So Lynn and Caitlin have agreed to do another session with us in the future. So we do appreciate that.
Marie, I just want to add on to that with that, what we're emailing out. If you haven't already, please add info@nathanielshope.org to your address book. And this will help make sure our emails get to you, to your inbox, and not spam or junk or somewhere else, because we know that happens.
Yes. That's great. So you'll be getting some correspondence with us along with a link to this webinar, so you can watch it again and again and again and all. But it's been very, very helpful. So thank you both for just your time and sharing your knowledge and your heart to want to help families, because it's a lot. But thank you for trying to peel the onion back and help families today. And we're thrilled at Nathaniel's Hope to be able to, our goal is to cheer you guys on your journey. We want to celebrate life, celebrate the unique kids that have, many of them grown into adults that have grown. And we want to just be sure that we're here for you year round. We've got a birthday club. If your child is not part of our birthday club yet, no matter what age, they can join our birthday club, and we'll celebrate them throughout the year. And we have different events throughout the year. We were just had a great day at Fun Spot and things like that. But we're here for you. We have free respite programs through Buddy Break. We do festivals called Make 'em Smile. In Orlando, we have a Christmas toy shop. We've got a book that tells a story, Nathaniel's story. We've got lots of things that happen year round. So please go to our website. We want to be here for you. We've got a prayer team that if there's something we can pray for you about, please let us know, because we want to stand with you, because we know this is a hard journey and there's things that have to happen every day practically you do, but we know that our ultimate source of hope and our strength comes from the Lord. I know I wouldn't be sitting here today if it wasn't for my personal faith in God and my journey with him being with me on my journey with Nathaniel, I wouldn't be sitting here today. So I'm grateful for his faithfulness, but he loves me and he loves you the same. And so he wants to be there for you. So we want to pray for you and hold up your arms in that time. So you can follow us on social media. If you love to be on Facebook, Instagram, Twitter, we're there. You can email us at nathanielshope.org. Or info@nathanielshope.org, or just visit our website often, because we try and put things up and we try and get information to you, but those are all the ways we try and communicate with you. So thank you so very much. And again, Lynn, Caitlin, thank you. Anything else you'd like to say in closing?
Enjoyed it. God bless you all. Thank you.
Thank you for having us.
Okay,
Thank you
great.
so much. And thank you all for joining us today. Keep a lookout on your email this week. We will be sending out follow-up from this webinar. So thanks for being a part today. Bye-bye.
Bye-bye. God bless you.